May it please the Court. Barbara Reisberg on behalf of appellants Jill P. Mitchell individually and Jill P. Mitchell as trustee of the Jill P. Mitchell Living Trust dated June 7, 1999. Throughout this argument, I'll refer to the individual as Ms. Mitchell and her trust as the trust for ease of reference. This case arises from an order denying a motion for attorney's fees following a voluntary dismissal. The initial case that was brought by U.S. Ameribank against Ms. Mitchell, the trust, and two other defendants who are not participating in this appeal was an action to enforce guarantee agreements which served as security for a series of loans to corporate borrowers. I might add that neither the individual nor the trust had any interest in these corporate borrowers. The guarantee action did not have a response, and a motion for default was filed probably about a year after it was initially filed. So it would have been filed in 2010. The motion for default was at the end of 2011. Thereafter, it was another year before a motion for a final default judgment was filed. That was never heard. Upon receiving notice of it, Ms. Mitchell sought counsel and filed a motion to vacate the defaults. That was filed in January of 2013. That matter was heard on March 26, 2013. Prior to that time, the bank had sought discovery to defend the motion. After the hearing on the motion, the judge deferred ruling and asked for additional discovery and evidence to be presented. Thereafter, Ms. Mitchell, who had already, I take it back, the trust owned a piece of property in Michigan, which was part of the collateral for the corporate loans. There was a second mortgage on a property in Michigan, and the bank sought non-judicial foreclosure under Michigan law. Under Michigan law, it's very simple. It's a very simple procedure, provided there is no other action pending for the debt for which the second mortgage provides security. At the time that the non-judicial foreclosure was filed, the action on the guarantees was still pending. Thereafter, the trust filed an action to set aside the foreclosure as being improper and in violation of Michigan statutes. In addition, she sought to set aside the second mortgage itself because it was based upon fraud. 6 months later, after many months of litigating a motion to vacate default and taking discovery, the bank voluntarily dismissed its claims in the guarantee action against both Ms. Mitchell and the trust. 3 days later, the bank filed a motion for leave to file counterclaims and third-party claims in the Michigan action against Ms. Mitchell and the trust. Prior to that time, there were no claims brought by Ms. Mitchell individually in Michigan. All that was pending in Michigan was an action by the trust to set aside the foreclosure. So the bank moved for leave to file a counterclaim against the trust for the guarantee and filed an action for a guarantee against Ms. Mitchell as a third party. So essentially what the bank did was it dismissed its guarantee claims here in Florida and simply refiled them up in Michigan. Thereafter, the appellants filed a motion for attorney's fees based upon the voluntary dismissal, and that motion was denied by the trial court. I'm sorry, I did not reserve. I would like to reserve 3 minutes, please.
What did you say?
3.
You said 3? Sure.
Yes. So the issues before this court are, overall, whether the trial court erred in denying the motion for attorney's fees, and the sub-issues would be, number 1, whether the trial court erred in failing to grant attorney's fees as costs pursuant to a provision in the guarantee, and number 2, whether the trial court erred in granting fees to the appellants as the prevailing parties.
Isn't the disposition of the case in Michigan going to determine who's prevailing and who's not in the sort of the global litigation that's going on here? And wouldn't that have a profound effect on the trial court in this case?
Well, what it doesn't have an effect on is the fact that the case here in Florida, the guarantee action, was dismissed and simply refiled in Michigan. And so, yes, if you take it to its logical conclusion, the case in Michigan would determine the guarantee issues because that is what's pending in Michigan. However, subsequent refiling of claims following a voluntary dismissal pursuant to Rule 1.420 of the Florida Rules of Civil Procedure, if you refile the claims, that doesn't do away with the responsibility to pay attorney's fees. This court has held that way in J.P. Morgan versus Golden in 2012, that a foreclosure defendant in a dismissed foreclosure was entitled to fees despite refiling of the action. The 4th District Court of Appeal has held similarly in Newdell versus Flagstar Bank, as well as Alhambra Homeowners. In fact, in the Alhambra Homeowners case, after the case was refiled, the plaintiff ultimately prevailed, and yet the 4th District Court of Appeal still held that the non-dismissing party was entitled to attorney's fees. Likewise, the 1st District Court of Appeal in State Ex Rel Marsh versus Doran has ruled similarly. So while it is correct that the guarantee action would eventually be determined by the Michigan court, that is not the issue. The issue is whether the attorney's fees are recoverable even if the case is refiled. So all that happened here is there was a dismissal and a refiling, a changing of forum. And I must point out that the action against Ms. Mitchell in Michigan was the first claim that had been brought by or against her on the guarantee or anything in the Michigan action.
The court in this situation, the trial court, was willing to reserve ruling on the issue of fees and pending the outcome of the Michigan litigation. Isn't that correct?
That is, well, he asked the parties to stipulate.
Yeah.
That was discussed on the record. It has not been briefed by the parties. There's no indication, because the judge said many things on the record, there's no indication as to what the basis of the ruling was, because the order of denial is a one-word order, denied.
Well, it appears to be part and parcel of the conversation that the court had with counsel about, in the event that, that the bank, or excuse me, if you were to prevail in Michigan, the counsel for the bank, I think, sort of said, I'm not committing to it, but it would seem like then they would be the prevailing party in this situation. And following that, there was apparently a discussion of some type where the court basically was willing to reserve ruling on the issue of fees pending the outcome of the Michigan litigation, which seemed pretty just and logical and fair, but you all objected to it.
Well, actually, it's in violation of Florida law. It's not briefed, so I don't have the cases to cite to today, but I did bring it up on the record at the time to the judge that Florida law does not allow for it, that there are several cases of Florida appellate courts which have found you can't defer it. It has to be paid. In fact, if there were a dismissal of the guarantee action here in Hillsborough County and was refiled in Lee County, the Lee County case could not go forward until the fees and costs were paid in Hillsborough County. So there's no case law to support the notion that it would be any different because the claims were refiled in Michigan. That would mean that litigants could simply dismiss cases and then refile them in forum shopping mode or for whatever reason, and if they did it in another state, they don't have to pay the attorney's fees as required by Florida law. So, as I said, because it's not briefed, I don't have the case to cite to you, but that is the law as I understand it.
I'm somewhat familiar with those cases. I know the line you're talking about. It just seems to me this is factually different than those cases, but again, we don't have them before us and it had been briefed, so we're off now on a venture beyond the scope of really what's in front of us today.
Yes. So, as I proceed, I believe that the fees should have been awarded as costs pursuant to 1.420D of the Rules of Civil Procedure. The actual guarantee itself reads as follows. In the event the guarantor should breach or fail timely to perform any provisions of this guarantee, guarantor shall, immediately upon demand by lender, pay lender all costs and expenses, open paragraph, including court costs and reasonable attorney's fees, close paragraph, incurred by the lender in the enforcement hereof of the preservation of lender's rights hereunder. And that's at in the record at both 106 and 125. The Supreme Court has consistently held that when fees are included in the definition of costs as they are in the guarantee at issue here.
Why isn't this included in the definition of expenses?
I believe
It doesn't say costs per ren, it says costs and expenses per ren.
it says costs and expenses, and there's no Oxford comma after the word cost to suggest that they should be referred to separately.
So, but that's a phrase, cost and expenses. However, costs under Rule 1.420 is a term of art in itself, is it not? Court costs.
It is court costs, but the case law
So the phrase costs and expenses isn't the same, would it be?
I believe that costs and expenses are the same. For example, this court ruled in Fleet Services versus Rice, the following language supported an award of attorney's fees as costs. I understand that I must pay the bank any expenses it incurs in collecting what I owe it to the extent permitted by law, and that this includes reasonable attorney's fees and court costs if the bank sues me to collect.
Right. And that was, when was that?
That was in 2003. More recently, in 2012, this court decided Raza versus Deutsche Bank. Based upon the following language, it upheld, don't hold me to it, it might have been reversed, but essentially the court's decision was that the fees could be awarded as costs under the following language. The note holder will have the right to be paid back by me for all of its costs and expenses in enforcing this note. Those expenses include, for example, reasonable attorney's fees. Likewise, in Lopez versus Bank of America, this court held in March of 2014 that a court may award attorney's fees as costs to a defendant in a dismissed action if the applicable agreement or statute provides for such fees and the defendant has properly given notice of intent to claim fees. Yet another case out of the 4th District Court of Appeal.
I agree that attorney's fees may be awarded as costs even if under the law if contract provides for it, although to tell you the truth personally, I think that was a stupid move for the Supreme Court when it allowed that. But we're getting awfully fuzzy if we're saying just basically anything in the paragraph that says, you know, I'm going to pay the bank back what it has to spend in order to recover this, you know, is costs under Rule 1.420. I mean, it has become quite fuzzy, such that basically we're doing away with the American rule anytime you have a commercial transaction.
Well,
I'm just telling you what my philosophy is. So I'm telling you that I am inclined to be very strict about that.
Understood. As far as being strict, however, I must point out that the guarantee itself was drafted by the bank and should be construed against the bank. And going back...
See, the thing is, I don't see, it's construed against the bank, you know, if it is not, you know, clear. But the question is whether court costs under 1.420 include expenses, as that term is used in that paragraph. And
well, this court...
I kind of doubt that.
This court determined in Raza versus Deutsche in 2012, using the word expenses.
Soon to be 16.
I'm sorry?
There are 14 of us, soon to be 16, and we can disagree with each other sometimes.
Understood. With respect to a recent decision of this court, The Creamer case, which I'm sure that my opposing counsel will argue, I submit to this court that case is pending rehearing and has been for a number of months, and that does make the distinction between costs and expenses. I can't...
Some brilliant judge wrote that, probably.
I don't believe it was you, sir.
No, I didn't say it was.
Okay.
I said some brilliant judge.
Well, it does make the distinction between cost and expenses, and it is inconsistent with other decisions of this court. And so the fact that it's not a final decision, I don't think that it can drive this decision, though it is pending rehearing. I suspect that whatever happens in that case, based upon the fact that there's some amicus briefs filed, that there will be a request for a rehearing en banc, no matter what the decision may be. So getting back to the argument, we believe we're entitled to fees as costs. There was a suggestion or an argument by opposing counsel that the motion itself was not timely because of the fact that the initial motion raised a request for attorney's fees and costs as the prevailing party and did not specifically raise the issue of fees as costs pursuant to 1.420D. I submit to this court that that doesn't make the fact that the argument was raised later untimely. It was raised by supplemental memorandum before the hearing. No objection was made at the hearing. No request to further brief the issues was made at the hearing. Nothing of that nature, and so I think that any objection is waived. Moreover, we don't know what the judge's decision was. But with respect to timeliness, Rule 1.525, which was adopted by the Supreme Court in recent years, sets forth a bright line rule. And in various Supreme Court cases, which I've not cited in my briefs, I won't mention them, I understand it is a bright line rule. However, 1.525 is a notice provision, and the reason behind it is set out in the commentary by the Supreme Court in 2000. Rule 1.525 is adopted, establishing the time for serving motions for attorney's fees and costs. It in no way, we add a court commentary clarifying that this rule only establishes time requirements for serving such motions and in no way affects or overrules the pleading requirements outlined by this court in Stockman versus Downs.
Okay, Ms. Reisberg, just give you a heads up, you're down to 3 minutes. Use them as you please.
As for the initial argument or the rebuttal?
Oh, you're down to 3 minutes of your total 20. So
okay.
You can use them as you please.
So we submit that the motion was timely. In fact, this court has even acknowledged that there's a lack of guidance provided by Rule 1.525 in both Parrott Cove as well as the Gulf Landings case. With respect to the prevailing party issue, we submit that we would be entitled to fees as the prevailing party. Numerous cases, including the Florida Supreme Court, have awarded fees to prevailing parties, to a party as a prevailing party following a voluntary dismissal, regardless of whether there's an adjudication on the merits. The only aberration of that is Simmons versus Schimmel out of the 3rd District Court of Appeal, but this court expressly rejected that approach, which was looking at the likelihood of success on the merits. That was rejected by this court in the Dam case. With respect to certain of the cases cited by
You're down to a minute and a half.
Okay.
So I'm just,
I will,
if you want to reserve some rebuttal, you
I will
probably ought to
reserve
sit
the
down.
rest of my time for rebuttal. Thank you.
Okay.
May it please the Court. My name is Lance Curry, and I represent U.S. Ameribank. The appellants have advanced 2 arguments for fees as costs, one being under Rule 1.420 and a separate issue dealing with prevailing party fee provision in the contract, 2 separate grounds for attorney's fees and costs. With respect to the argument under 1.420, they've waived that argument by not including it in their timely filed motion for attorney's fees. As this court is well aware, Rule 1.525 says that any motion for attorney's fees and costs has to be filed within 30 days. That's a bright line rule that's strictly applied. And Rule 1.100B says that all motions have to state with particularity the grounds therefore. It's undisputed that the only ground argued in their fee motion was that they were the prevailing party under the contracts. Their motion did not mention Rule 1.420. It did not mention fees as costs. In fact, they've never filed a motion arguing those grounds. It was only the night before the hearing on the fee motion, some 78 days after the dismissal, that they filed this supplemental memorandum raising what they've described as an additional argument under Rule 1.420. That argument's untimely, and I would direct the court to the European Bank case from the 4th DCA, 2007. That case is correctly decided and directly on point. What happened there was the 4th District reversed an award of attorney's fees in favor of an individual named Sammy Slim. Slim had timely filed a motion for attorney's fees and costs, and he argued one ground, that he was the prevailing party. And then after the 30-day period ran, he filed an amended motion and argued a new ground for attorney's fees and costs that based on a proposal for settlement. The trial court awards him fees based on the proposal for settlement, and the 4th District reverses. And the 4th District said that Slim's timely motion for attorney's fees did not state with particularity his claim for attorney's fees under his proposal for settlement. And it also said that the amended motion that did raise the proposal for settlement was untimely. The same is true here. They timely filed a motion, and they specifically stated the grounds for attorney's fees and costs, and it was, we're the prevailing party under the fee provision. No mention of fees as costs or Rule 1.420. And a contrary result, the result advanced by the appellants, would undermine entirely the bright line 30-day requirement, because basically a movement for attorney's fees could come in and say, the grounds for my motion are X, prevailing party. And then the night before the hearing, or even at the hearing, they could come in and say, oh yeah, well, we've got 10 more arguments that we'd like to advance for attorney's fees and costs. The whole point of that 30-day bright line rule is to prevent that very type of unfair prejudice and surprise. It would also, if that position is accepted, it would also essentially be applying a lesser standard to fee motions than the standard applied to all motions. All motions are required to specify the grounds that is supporting them. And they've cited some cases that talk about the pleading requirements for fee motions. That's not what's at issue here. When you're talking about the pleading requirements, that usually happens in a pleading, in a complaint, or a defense. It's just telling someone we have a claim for attorney's fees. You don't have to state with specificity in your pleading what the grounds are for your request for fees and costs. And sometimes you can meet that pleading requirement in a motion if the defendant, for example, hasn't had the opportunity to file a pleading, but that motion still has to comply with Rule 1.100 and state with particularity the grounds. They did that here. They stated the grounds, and those grounds were prevailing party under the fee provision in the guarantee, not Rule 1.420, not fees as costs. And they mentioned the Tunison case, and that case is distinguishable because the party there, it was about, the whole issue in that case was about the specificity of the argument that was made, but the move-in in that case never changed their position. It was always, we're entitled to fees as a prevailing party. The issue was, well, they didn't attach the contract, they didn't cite the reciprocal statute, so that was the issue there, so that's distinguishable. And even if they had timely moved for fees as costs in their motion, that's not what this agreement says. That's not what the contract says. And as this court is aware, if you in a commercial contract, if you want to define costs to include fees, you have to do it unambiguously. You have to express a clear intent. Here, the agreements separately refer to costs and expenses, and then they provide examples of costs as being court costs, an example of expenses as being attorney's fees. We cited to the Creamer case, not because the language is identical, frankly the language is somewhat different than the language in our case, but the Creamer case, which was written by Chief Judge Davis, it makes the point that if you treat these things differently, if you treat attorney's fees and costs differently, then you're not defining costs to include fees. It's not a clear expression of that. They cited a couple of cases that I want to address, the Raza case, and there's also the Vivat case from this court, and they kind of seize upon the language that's used in those in the contracts there. But those cases are not cases where the court has said this language defines costs to include attorney's fees. Those cases are prevailing party fee provisions, and there's a difference there. There are a couple of cases that they cite, the Wilson case and the Fleet case, where the holding in that case is we look at this language and it does define costs to include attorney's fees, but those cases are distinguishable. The Wilson case from the Florida Supreme Court, 1993, it's about as clear as it gets. It says prevailing party is entitled to all cost, comma, including attorney's fees. You know, without a definition section, I think that's about as good as you can do it. The Fleet case, which was also written by Chief Judge Davis, it has a little bit more ambiguous language, but what it does there is it says the prevailing party is entitled to all expenses, including attorney's fees and court costs. So it lumps all of those terms, attorney's fees, court costs, all into the one word expenses, and the court found that that was sufficient. That's not the language that we're dealing with here. And I think the more important position here is, you know, the appellants and myself were arguing over reasonable interpretations of this language. If the language is ambiguous, if it's subject to differing reasonable interpretations, then the court should not struggle to find an intent to define costs as fees that's not expressly stated in the contract. And the Fourth District has made that clear in the Shawkoff case. It says courts are not going to do this. We're not going to strain to find intent to award fees as costs where it's not clearly expressed. Now, the one argument that they did make in their timely motion for attorney's fees is that they were the prevailing party, and the trial court denied that motion. And the appellants concede in their reply brief that that decision is reviewed under an abuse of discretion standard. The trial court did not abuse its discretion in this case. In fact, it did exactly what this court has instructed trial judges to do. And those instructions come from a recent case from this court called Tubbs. And what that Tubbs case says is that trial courts have a broad duty to, one, look at the substance of the litigation outcomes, not just the procedural maneuvers, and to not determine the prevailing party prematurely. And Judge Morse, I think you're absolutely right that what is going on here is all of these claims are now swept up into the Michigan action, and whoever wins up there is going to be entitled to argue that they are the prevailing party entitled to all their fees, all their trial court fees and costs. So it's all about not determining the issue of prevailing party prematurely, especially where you have these situations of parallel litigation involving related claims and parties. So here the trial court had a hearing and said, I want to know more about the parallel litigation. What's going on? And the parties gave the trial court that information. And what did that information indicate? That when the bank dismissed its claims here in Florida, there was pending litigation in Michigan arising out of the same loan transaction and involving the same parties. Now, the appellants make a big deal of the fact that, well, Jill Mitchell individually was not a party already in the Michigan action. Her trust was. She's the sole trustee and the sole lifetime beneficiary of the trust. And it all arises out of the same loan transaction. So I think there's a distinction without a difference there. The trial court also learned that 2 days after dismissing the claims in Florida, the bank sought leave to file those claims in the Michigan action. It's not like they waited 6 months to figure things out. So the Michigan court granted leave, and the bank's claims against the appellants are now pending in the Michigan action. The bank learned the trial court learned that the reasons for the bank doing that is they wanted to avoid wasteful parallel litigation in Florida and in Michigan involving the same loan transaction and related parties. Why not litigate it all in one place? You avoid the waste of resources and the risk of inconsistent results. The trial court also learned that much like the parties in that Tubbs case, the parties here have not achieved their desired litigation outcomes. The bank wants to collect on the guarantees or at least mitigate its losses on the loan that it made. The guarantors want to avoid paying on the guarantees. Those litigation objectives are still pending. They're up there in Michigan, and the parties have the full opportunity to litigate those things. The trial court considered all of these facts and then denied the appellant's motion. There's no abuse of discretion here. The trial court got it exactly right. Now, they also cite to the case that I'll address real quick is the J.P. Morgan case. That case is readily distinguishable because there's no parallel pending litigation, related litigation going on in those types of cases. Those are cases where someone comes in and says, I'm going to voluntarily dismiss my claims, and then they realize there's a cost motion against them and say, well, we'll reinstate them in a new action. That's not what we're dealing with here. There was existing pending related litigation going on at the time that the bank dismisses claims. This is an issue for the trial judge's discretion, and the trial judge appropriately applied his discretion in this case. If the court doesn't have any questions, I'll just ask that the court affirm.
Thank you, Mr. Kirk.
Thank you.
Okay, Ms. Riceberg, better talk fast.
Will do. First, with respect to the Tubbs case is distinguishable from the matter at bar. The Tubbs case involved cases pending in Hillsborough County and I believe it's Lee County because there was a venue provision in a contract that was being litigated in Hillsborough County, and the property that was the subject of a mortgage was in another county. The mortgage claims were voluntarily dismissed, and this court reversed an award of attorney's fees following that dismissal because it was determined that the mortgage claims had become moot because the first mortgagor had achieved a foreclosure judgment and there was not sufficient equity in the party to recover. And thus they dismissed the claim, and the note claim, the note which was secured by that mortgage, remained pending in Hillsborough County. The two go together, and so that remained pending. This is a very different case. There's a guarantee action. The case is dismissed, all the claims are dismissed, and refiled in Michigan. Very different case. With respect to Ms. Mitchell, there is a difference. Ms. Mitchell and her trust are two separate parties. Ms. Mitchell was not the subject of parallel pending litigation in Michigan at the time of the dismissal, and thus she should be entitled to fees under Tubbs. Tubbs will not disallow recovery in that case. Now, with respect to whether the motion for fees was filed timely for fees as costs, we submit that it was. The substantive basis was raised in the motion, the substantive basis being the guarantee itself. Each of the cases cited by opposing counsel, the European Bank case, the Jaffe versus Baggy Bunny case, and the Landmark case involve situations where there's a change in the substantive basis stated in the timely filed motion, change between that and what is argued before the court or what is in the supplemental memorandum.
Okay, your time is up.
Okay. May I just make a prayer for relief?
Sure.
The appellants request that this court reverse the order denying the fees motion and the cost motion and remand them both for an assessment of costs and fees and entry of judgment in favor of the appellants, alternatively in favor of Jill P. Mitchell individually, because there was no pending litigation in Michigan at the time of the dismissal. Thank you very much.